Mathews sir, today Supreme Court dismissed our petition seeking abolition of designation system. What is the way out?
Okay. Hemali, thank you for your question. You are one of the petitioners in the petition seeking a declaration that section 16 and 23(5) of the Educate Act is unconstitutional. When I filed the petition, and even after it was heard, it was almost certain that the petition will be dismissed. So therefore the dismissal of the petition does not amount as any kind of a surprise. It was very much on the expected lines, but it certainly offers a certain amount of disappointment. But it does not in any way hamper us from pursuing the goal. What is the goal? A just and fair, equitable justice delivery system, where all litigants, all lawyers are equally and fairly treated. And today the scenario is the entire judicial system has been hijacked by a few families of lawyers and judges, maybe some politicians also. And there is actually hardly anyone to speak against it, because a young lawyer in his early 40s and in 50s, he cannot criticize the institution, he cannot say anything, even the greatest of injustice which happened in his own eyes, he will not react because he has no professional prospects, a career, unless he becomes a judge or as a designated lawyer. Both of us are entirely at the mercy of the judges. So the one single damage, irreparable damage, the greatest catastrophe that has been inflicted on the legal profession because of the designation system is that the legal fraternity lawyers have become subservient, compliant, subservient. So the vitality of the independence of the judiciary depends on the independence of the bar. Bar is the fourth estate. If the bar has become servile, and that is what I see everywhere, if the bar has become servile, and Blackstone said bar is the fourth estate, and the bar has become servile, what is at stake is not merely our institutional judiciary, but even the future of our democracy. And therefore, the abolition of the system of designation of lawyers, senior advocates by the judges, and the collegium system where they appoint themselves, where the judges appoint themselves, these are one of our core agenda. I am blamed for leading a vilification campaign. That is a misunderstanding. I have nothing against the institution, judiciary. In fact, I believe many may not be considering me as a part of the institution, but I joined the bar. I joined the Jaw College in 1979. Then after joining, I left because I was told here only those with the sons and with a godfather alone can survive. Then I came back, joined in just another 2 years. I joined and enrolled in 84, and since then I am an active practitioner. And then in 2003, when I came across the kind of corruption, injustice and lack of transparency in Delhi, particularly in Delhi, the ill treatment of lawyers, I decided, yes, I must organize lawyers and we must seek correction. So any institution which does not permit criticism, say in Korea, North Korea, in China, in many countries, criticism is at great peril. But in democracy, the essence of democracy is right to dissent. And the institutional judiciary should certainly be encouraging freedom of speech, the right to dissent, not about the right to criticize political leadership, to criticize the institution. So the judiciary, time that the judiciary should introspect. And the campaign which I lead, consider that we have an agenda of 21 items, and the video recording of the court proceedings, which our campaign has started in the year 2010. It was one of our agenda. Then the collegial system abolishment, appointment of judges, we strive our best to abolish it. and this designation system, transfer of judges, all these are very core to our heart. Now the point is, I expected the reform is very difficult because the system suits a certain people, elite people. And today, the other day, I had a case before court number 6. My item was SST. I think item number 7 or 9 was of Mr. Harish Advi. The entire board was discharged. I am not blaming the judge for discharging the entire board, which is every day we see in the Bombay High Court. So therefore, there now the impression gives is certain lawyers have a special rights, special privilege. Harish Advi was told, maybe right or wrong, I am not sure. He charged 1 crore and 10 lakhs. I have nothing against him charging, he can charge any amount, I am not on that. The issue is, the Supreme Court, I said in Article 32 and Article 136 gives a right to any person aggrieved, in the case of Article 136, to approach the Supreme Court without recourse to any, from any order, an appeal will lie, leave to appeal will lie. And Article 32, any citizen can approach the Supreme Court for the enforcement of the fundamental rights. Now, you think of that, 32 and 136, to properly function, we need to have a Supreme Court of 1000 judges. If everybody can go to the Supreme Court for the enforcement of the fundamental rights, then we don't require any other court, and you need a Supreme Court with 1000 judges. So therefore, Article 136 and Article 32 are provisions which are problematic, because the founding fathers probably didn't have thought of the kind of volume of work, the only pressure on the court. Now, I consider abolition of the designation system is of paramount importance for a more fair and equitable justice delivery system. Our society is feudal, and this system makes it all the more concrete. Look at the scenario. I don't intend to criticize anybody, but just to make my case more clear, I just making some references of individuals. See, Abhishek Manu Sindhi was anointed as a senior counsel at the age of 34, because his father was a very prominent lawyer. It happened with Rohindra Nariman at the age of 37, Rahul at the age of 39. So look at a very prominent lawyer, got his son anointed as a senior counsel or a judge. So there is hardly, from the elite class of lawyers and judges who have been lawyers and judges for generations, every member of their family is a judge or a lawyer. And the ordinary class, and that shows the reflection. See, in the Supreme Court you go, I have collected the details of almost everyone. There is nobody outside in the Supreme Court as a senior lawyers. There is hardly anybody outside from the system. Look at the institution judiciary also. See, look here, we have the two senior, who are the senior most judges? All the immediate relatives of the former judges, senior lawyers, and therefore the common man, the ordinary people, they have no place there. The sons and daughters of the common man have no place either in the higher echelons of the justice delivery system, either as a lawyer nor as a judge. And this is, unless this system, unless the senior designation system is abolished, I don't find any future for our justice delivery system. And see, the judges come, they are there for a couple of years, 6 or 7 years. The lawyers, the senior designated lawyers, and their voice is the voice of the legal system. What they say is the law. And they are there perpetually, and they have got such a, they enjoy so much of power that the judges are unable to take a different call. And that is why I expected the petition to be dismissed. Now, what is the way out? See, the designation system has to go, there is no doubt about it. Otherwise, today what is the scenario? An average SLP is heard, dismissed in just 93 seconds or even less. And in the case of an ordinary litigant in Bombay, he files a petition Article 226 in the High Court. that petition is dismissed maybe after hearing 5 minutes, 10 minutes, and there is no right of appeal, there is no intra-court appeal, only appeal is to the Supreme Court, and that is dismissed in seconds. And there is a remedy of review petition, but review petitions are dismissed in chambers. So it leads to denial of justice, and this the limitations of the justice delivery system to make it accessible to the people to render justice, hear them, make the litigant public live with no other option than to engage designated lawyers, and they are extremely expensive. So it has destroyed the bar, it has led to denial of justice to the common people, and it is, I should say, it is a great aberration. And what is the way out? See, now fortunately the decision on this case, here myself and 6 lawyers and Mrs. Manisha Mehta, she is an entrepreneur, and another activist and industrialist, they were parties in the petition. So this case does not involve any facts, and there is no res judicata, there is no finality, there is no estoppel against law. So therefore this issue will have to be re-agitated, and we will certainly re-agitate it. And and I can say any number of example also. In Judges 1 case, a 7-judge, of the 7-judge bench, 4 judges said consultation does not mean, consultation means only consultation, does not mean anything beyond that. Before the ink of that judgment was dry, a petition was filed saying that the judgment is erroneous, and a 9-judge bench was constituted, and in 1993 2nd judge's judgment came. So as a legal principle, there is no estoppel against law. The validity of a judgment ideally is does not depend upon the strength of the bench or the inter se majority. For a principle of res judicata, the majority decision is binding. But when it comes to precedent, what is binding in a precedent is the reason for the judgment and nothing else. So since law has no estoppel, there is no difficulty in re-agitating the issue. And anybody who is familiar with the CPC, Order 7, Rule 11D, the empowers the civil court to dismiss a suit if it has no jurisdiction to decide the matter. And Order 7, Rule 13 says that in dismissal of a earlier petition suit on the very same cause of action will not act as a bar. So therefore, there is no estoppel against law. These issues will certainly have to be re-agitated, and I am sure the courts are man-made institutions, human institutions. So it is human, and I am sure, and we place the greatest of hope in the institutional judiciary, and our efforts is to make it more citizen friendly, more equitable, and not less discriminatory and fair to all. We are very hopeful that this current decision is certainly is a human error. It will be corrected.